if you could just list, I mean, it's very important to understand that if at all this argument goes through, that we're going to look at a judgment that stands settled by this court through the process being, what are those grounds?
My lord, the process goes back to the old principles of natural justice. So, Audi Altrum Partem and
No, I think it's because it was not a question of not being heard. I think let's as far as these cases, there may be cases where inquiry may be required. Is this one of those cases? I mean, if one of the judges says something, I mean, either you say he is not saying this thing, that's a different thing. And it was reported widely, recorded everywhere, and he could have said, I've been misquoted, I've been whatever, that he didn't do. He was a retired judge, so he could come on TV and say whatever he wanted to say. So that aspect, I mean, maybe there are cases which require inquiry, but probably this may not be one of those. My lord, so I'm back to really question of reopening the issue on rendering an opinion to the president, whether and as far as the effect is concerned, I think effect, suppose it was a unanimous decision, suppose. And even if you take out one judge, it won't make any difference to the judgment. But here, it hangs by a thread of one vote. So it would make a material difference if they all were quitting for whatever wrong reason or right reason, or they were all convicted, or even if you remove one, it won't make any difference to the judgment. But here, it will have a practical significance on the judgment, and we're left with what the learned judge had subsequently stated that how he acted. So there may well be other cases where you cannot do it because you would require an inquiry. Do we require an inquiry? In this case, is a question for you to address.
My lord,
I will add to the question. I will add. Suppose if we believe that there was a bias, what was the question of public importance for the government to ask the court to give answer, number one. Number two, whether, since this judgment has been implemented, whether this question cannot be looked into in some other case, some regular case during appeal, in any other case. So what is the public importance matter in it?
My lord, the second question first. Insofar as the judgment is concerned, whether your lordships can look at it in appeal, obviously your lordships can, and your lordships can overrule it. It happens all the time. Your lordships have very recently done it in a case of which the reasons came out yesterday. But that's a different issue. The question is whether it's a question of public importance. There I would say that, my lord, once the president has framed the question and sent it to your lordships, the public importance aspect is decided by the president. But coming back to the question of my lord the Chief Justice, my lord,
and just if I may just add one more thing to it before you may also incorporate that. Can we ignore the elephant in the room? Martial law. I mean, can we really ignore that? I mean, can we not take that into, can we not factor into that? I mean, I would, a trial where the violator of the Constitution had a vested interest in the matter, the prosecution, he becomes a prosecutor before a court of law under martial law. It cannot be categorized as a normal court under normal circumstances, at least. So can we just completely overlook this and go into the finer aspect of the matter, or this would be a crucial factor to consider?
My lord.
And had they taken oath under PCO at that time?
Yes, my lord. Because what happened was PCO came in 1981, as your lordship will recall, 24th March 1981. So but an oath was immediately administered after 5th July 1977.
So even if it's not an oath, it's a physical violence part of it.
And the oath is mentioned in the Begum Nusrat Bhutto judgment, particularly by my Lord Mr. Qaisar Khan at that time. My lord, may I take it a step further? Your lordship says that if it was a judgment, let us assume it was
we question. We don't say we question.
My lord, yes. Okay. Well, as your lordships observe, that if it was 7-0, and it later on turned out that one of the judges' conduct suffered from a reasonable apprehension of bias, I would respectfully submit that even then it would be a case for your lordships to declare that it was an unsafe judgment. And why, my lord? Because your lordships' deliberations are not public. One does not know what happens after your lordships have heard arguments in a case and go back and deliberate. Who was how powerful in terms of persuading the others and what role he played? It would be difficult to determine that. So once reasonable apprehension of bias is established in
but you are entering into the realm of conjecture. I'm grounding myself on the realm of facts.
My lord, yes.
The fact is simple. Yes, you may, one person may be so persuasive that he changed everyone else's view, but that's conjecture. This I know as a fact that he said something. So, yes, you're completely right, but why go into conjecture when we have a fact? There may be other cases we may have to conjecture that way. That may well be. But do we need to do so in this case?
Not really, but I was responding to a hypothetical assumption. My lord, if your lordship looks at the High Court judgment, in the High Court judgment, it was 5-0, which was later on upheld by the Supreme Court. It was 5-0, written by...
I think let's stay clear of the High Court judgment. Let's stay with the Supreme Court, because that will open another realm altogether.
Your lordship will find...
Because we are looking at the judgment of the Supreme Court.
Your lordship will find, it's up to your lordships, but your lordship will find that there are far more categoric statements by the sitting judges of the High Court of that time and by judges of the Supreme Court, not only Mr. Justice Naseem Hassan Shah.
No, but then the other question will arise, then what were the judges of the Supreme Court doing?
Was that also raised as a ground before the Supreme Court?
Could you, my lord, effectively are re-arguing the appeal.
And an application was moved before the learned judge himself, requiring Mr. Justice Maulvi Mushtaq Hussain to recuse himself.
Right.
And he did not recuse himself.
I think there's an added thing that the trial took place in the High Court.
In the High Court.
Ordinarily, it would have been held in the Sessions Court. Now, we need to, I think later they will address us on the point whether it was by consent or opposed, because that also has to be clarified.
My lord, much better people will clarify that to your lordship, but my cursory examination of the record suggests that the order was made even without a notice to the accused, transferring it from the Session Court to the High Court, constitution of a 5-member bench, and cancellation of the bail earlier granted to him.
So sorry again to nudge you, but can you just focus on this aspect? We have not lost sight of these are very valid questions, but we want more from you from this constitutional aspect.
My lord, constitutional aspect, the submission is that the tests which your lordship have evolved in the constitutional domain.
So you have primarily referred to one judgment from our jurisdiction, the Governor General's reference. The other one is the Pinochet judgment.
Pinochet judgment.
If you can sort of give us more citations on this aspect.
If your lordship will see,
has there ever been a case where a judge later confesses or admits that he did wrong? Is there such a case?
My lord, in the common law jurisdiction, I have not come across one.
Okay.